Hello, my treasured viewers, and so we are back again on Human Rights Heralds. Do you know that 70% of Nigerian marriages are as good as divorced? When I say this, what I imply is that many couples are simply hanging on a relationship that has since turned sour. To many couples, marriage has become a prison. Marriage has become a trap from which it has become difficult for them to extricate themselves. That is what many marriages have turned into. Hello, my name is Ogochukwu Onoha, your usual anchor on a half hour with the Human Rights Wizard. And the channel, as usual, is Human Rights Heralds. Welcome to today's episode. Marriage is a prominent and paramount human institution. It is the agency, the legitimate agency through which all of us as human creatures came to the earth. It is the foremost human institution, the first agent of socialization that a child, the human child, usually encounters before the opportunity to interact with other agents of socialization present themselves. It is for this reason that we should be worried about the increasing trend of collapsing marriages in the human society today, something that used to be foreign, at least in an African context. Right? As I speak with you today, divorce in marriages has become an abiding, a widely spreading phenomenon of African marriages. Is it surprising, therefore, that for some time now we have devoted close to 6 videos on issues that relate to marriages, issues that touch one aspect of marriage or the other. And today's video is no exception. My treasured viewers, join me as today we discuss dissolution of a statutory marriage. Dissolution of a statutory marriage. If you are joining us for the first time today, you are welcome. But this is not our first or second video on issues that relate to marriages. So, you will need to go back and watch our previous episodes on marriage. Today, however, we'll be talking about dissolution of a statutory marriage. That marriage that involves going to a law court, that involves going to a local government registrar, I beg your pardon, going to the local government office that is known as the registry office to declare the intention to get married, and to have a register given to the couple to sign, after which, at the expiration of 21 days, they are issued with a marriage certificate, following which most people now proceed to a church to have the marriage solemnized by a priest. That is a marriage that we refer to as a statutory marriage. In Nigeria, that kind of marriage, that brand of marriage, is regulated by two legal instruments, two laws, or two bodies of laws. One of them is the Marriage Act, passed into law in 1914 and inherited by Nigeria at independence in 1960. And the Matrimonial Act, passed into law by the Nigerian topmost legislature, the National Assembly, in 1970. The other kind of marriage is called customary marriage, contracted under the customary law. That marriage, the customary marriage, does not require going to a church for a white wedding. The wine carrying and the other marriage rites that we perform in our tradition are all that are required in a customary marriage. Today, however, we are not discussing the customary marriage, but it was only necessary to distinguish between these two broad forms of marriages. Our interest today is on dissolution. When marriages turn sour, it gets to a point when the only solution is to have the marriage dissolved. But before we move on further, I'd like to put it to us that the purpose of this video, the aim we hope to achieve from this video, are fourfold. One, to discourage partners in a marriage contract from engaging in conduct that will result in divorce, so that many more marriages will last until death do the partners part, as we usually pledge during our wedding ceremonies. The second objective is to encourage those who have been trapped into or imprisoned in a marriage that has become palatable, in a marriage that has turned sour, where couples have become arch enemies instead of the loving, harmonious partners they envisaged when they made that vow to dedicate their lives to the service and the betterment of each other. To encourage people in such a marriage trap that there is a way out, that the marriage can be dissolved and liberate the partners from bondage once the marriage has turned sour. And then the third objective is to educate young people who are not yet married, but who we understand aspire to do so in the nearest future, to educate them on what it takes to make a marriage long-lasting and satisfying to both partners, and harmonious and contributory to the welfare of the society. That's the third aim. Then the fourth aim, to educate the general public, members of both families in a marriage, friends and well-wishers, that there are things they can do to help their loved ones who are in a marriage contract to do better. One is to stop interfering in their affairs. Second is to stop married couples, to discourage them from taking their affairs to third parties, most of whom come into the marriage and make the situation worse, aggravate an already worse situation. These are the objectives behind our video, our discussion today. So, without further ado, we now delve into the discussion. First of all, we need to understand that in matters of marital divorce, when a marriage is to be dissolved, that the first court of instance, the first court that has the right to dissolve a marriage is the High Court. The customary court and the magistrate court have no right to dissolve a marriage. In the language of the law, we will say the magistrate court and the customary court have no jurisdiction. The scope of their power to look into issues does not include granting divorce to married couples. So, a divorce case must be handled first by a high court. And failure to resolve the case, the matter can move from the high court to other court levels. Secondly, in divorce proceedings, that is, in law cases, in lawsuits, cases in a law court involving divorce, Nigeria is regarded as one constituency, one unit, one legal unit. So the case can be initiated at any high court, anywhere in Nigeria. So it does not have to be a high court in the state where the marriage was contracted in. Any high court anywhere in Nigeria can receive the application to dissolve a marriage. The other point, the third one, that I need to point out is that the law does not permit divorce in a marriage that has not lasted for up to 2 years or more. If the marriage is still below 2 years old and one of the partners is applying for a divorce, the law court will reject the application. But there are some exceptional circumstances, exceptional factors that can still make the court grant the divorce. These factors constitute the grounds. I've listed them here. The grounds for the dissolution of a statutory marriage. First of all, when one of the parties to a marriage contract approaches a law court requesting for a divorce, the court does not immediately dissolve the marriage. There is usually an attempt by the court system to bring about a reconciliation, with the lawyers for both parties participating and sometimes the judge also participating. But if the judge participates in the efforts at reconciliation, the law no longer permits that judge to preside over the divorce case hearing, except both partners in the marriage contract permit the judge to do so. But if one partner objects to that same judge who took part in trying to reconcile them presiding over the divorce proceedings, then the judiciary must provide a neutral judge to preside over the case. First hearing. The court does not ordinarily dissolve the marriage or grant divorce to the party asking for it. First, the court will rule that the partners or the parties to the marriage should separate temporarily. In the language of the law, it is called decree nisi. Decree nisi. It implies a temporary separation. The man either leaves the house where he and his wife cohabit and stays somewhere, or if it is more convenient, the woman will leave while the man stays with all the children or with some of them, while the woman takes the remaining children with her. Most of the times, however, the woman retains custody of the children while the man moves away wherever he decides to stay. Most of the times. Sometimes, however, there may be circumstances that will warrant the man himself taking custody of the children completely. They stay apart from each other for some time. The purpose of this is to see whether the desire for each other could be reawakened in them. Whether that love, that attraction they had for each other at the beginning will be reawakened. If this happens, reconciliation could follow, and then the need for a divorce will no longer exist. But if after staying away for 2 years, staying apart from each other for 2 years, there is no reconciliation, then the partner who initially brought the matter to the court will go again and reactivate or renew his application for divorce. This time, the decree absolute applies. The court will now rule that the couple be separated permanently. That is called decree absolute, which tantamounts to divorce. That is, which means the marriage has been dissolved. You have a question. I can almost sense it. Drop that question on the comment section. You have an observation, drop it on the comment section, or chat me up on WhatsApp using the number 091 333 01790. Or you can send me an email. You can send an email on the address humanrights.wizard@gmail.com. That's humanrightsheralds.wizard@gmail.com. The first condition for a divorce, the first factor, so to say, the first ground on which a partner can apply to a law court for a divorce is 1, refusal to consummate the marriage. Refusal to consummate the marriage. Consummation of a marriage means the first act of sexual intercourse after marriage. If after marriage, one partner persistently refuses to have sex with the other partner, when that partner is requesting for it in a friendly manner, the partner for whom sex has been denied, even when he or she has requested for it in a conciliatory or friendly manner, has enough ground to apply to a high court requesting for a divorce. Because marriage cannot exist reasonably without sexual relationship between the partners, except there is a fundamental problem responsible for this. Now, the request for sex must be done lovingly, must be done conciliatorily, assuming there was an issue, responsible for the other partner, declining. It is only when it is requested in this friendly or conciliatory manner and the other partner persistently refuses. That is why the partner for whom sex has been denied can apply to a high court requesting divorce. The second is adultery. If one partner genuinely or reasonably suspects that the other has committed adultery and he or she cannot bear it, it is enough ground for him or her to apply to a high court requesting a divorce. Now, because the act of adultery, a kind of illicit sex, is done secretly, it is done in hiding, it is not a requirement in the law that the partner accusing the other of adultery must provide a proof that he has seen her or seen him committing adultery. No, it is not a requirement in the law. Some circumstantial evidence is what the law or all the law requires. And what do we mean by circumstantial evidence? For example, familiarity and opportunity. Familiarity and opportunity are examples of circumstantial evidence. I'll tell you how. A woman suspects that her husband is becoming too familiar with a certain woman. Too familiar. Because of the way they speak with each other. Because of the way they conduct themselves in public. The woman becomes suspicious that it is possible her husband has been committing adultery with the other woman. It is enough ground, that is enough evidence in a law court. Or the man is the one who suspects that because of the way his wife speaks with another man, because of the way she conducts herself before that man, or possibly the way she speaks with him on the phone, that it is possible his wife has been committing adultery with the other man. It is enough evidence before a high court for such a husband to request for a divorce. Then we'll talk about opportunities. Yes, opportunity is a kind of circumstantial evidence. How? A man and a woman has passed the night in the same room. That is opportunity. And the man's wife suspects that having passed the night in the same room with that other woman, that her husband has committed adultery with her. It is a reasonable ground. Or the man suspects that because his wife has spent a night in the same room with the other man, that they have committed adultery. It is enough ground for such a partner to apply to a law court requesting divorce. Third, circumstantial evidence. A partner has contracted a venereal disease. A venereal disease, that is a sexually transmitted disease that she couldn't have got from her own partner because her partner is healthy. It is enough ground to suspect, enough evidence that the man or the woman has committed adultery and contracted the disease through it. Fourth, a woman has got pregnant within a period where it was not possible that her husband was responsible for that pregnancy. In a period or within a period where she has not been exposed enough sexually to her husband and she's pregnant. It is enough ground for her husband to suspect that she has committed adultery. And he can apply to a high court, presenting this as evidence, and requests a divorce. Then, fifthly, a blood test has confirmed that a child of the family is not related biologically to the woman's husband. It is enough ground for the man to apply to a high court requesting divorce, because the child probably was fathered by another man. And then, the sixth point. It happens that a man suspects that a neighbor of his, possibly a relation of his, has had a carnal knowledge of his wife because of his frequent presence in his matrimonial home. It is enough evidence to apply to a court for a divorce. Or that a man has found a particular man, possibly his own relation, in his bedroom for no reason. It is enough ground for him to suspect that his wife has committed adultery with a man. So these are what we refer to as circumstantial evidence that can get a law court to grant divorce to the partner who has applied for it. That is all on the adult. The other ground is rape, sodomy, or bestiality. We know what rape is: a forceful carnal knowledge of somebody is rape. A woman can be guilty of rape if a woman forces a man to have sex with her by some means, gunpoint, or by getting another woman to overpower him and force him to have sex with her. Or a man had sex with another woman. That is rape. Then the man who as husband or the woman who as wife can apply to a law court for a divorce to separate from the man or the partner who has done this. Sodomy means gay sex relationship. If a husband engages in a gay relationship, that is, he's been having sex with a fellow man, it is called sodomy. If a wife has been having sex with a fellow woman, it is called lesbianism. Both are examples of homosexuality. It is enough for the partner who is the injured party in this situation to apply to a law court requesting divorce. Bestiality means sexual relation, sexual intercourse with an animal. A man having sex with a dog, with a goat, with a horse, with a cow, with a chicken or hen. Or a woman allowing an animal to do that with her, this is bestiality. The partner who is injured by this has enough ground to apply to a court for a divorce. And then we'll talk about cross petitions. If a man has applied to a law court requesting divorce, and his wife has applied to the same law court or to an equivalent court in the same region or another region of the country, requesting for divorce. This is called cross petition. That means that both partners no longer want to live together. Each is applying for a divorce. Then, of course, the court automatically dissolves the marriage. 5. Excessive hardship or depravity. We all know what hardship means. Sometimes it is the result of low income earning. The family simply cannot cope economically. They are suffering. Children can fall sick and there is no means of treating them or giving them medical treatment, and possibly the child dies. There is no food, so the children are malnourished. The parents themselves don't eat very well. The parents cannot clothe themselves, let alone clothing their children, and so on and so forth. Children can't go to school because there is extreme hardship in the family. And sometimes the hardship results in depravity. It results in the woman, for instance, succumbing to sexual seduction by a man, something she wouldn't even think of if she were comfortable economically. It is an example of depravity. Or of the man misbehaving, going out to beg, going out to do odd jobs that lower his dignity just to survive as a married man. If conditions have got so low, and one of them thinks he or she cannot continue and applies to a law court for divorce, the court will dissolve the marriage. And then we talk about unreasonable behavior. Behavior that the law considers unreasonable can include extreme misconduct. It is not a minor, any behavior, any misbehavior that can be tagged can be tagged unreasonable. But there are extreme ones like alcoholism. Somebody overindulging in drinking alcoholic beverage. Secondly, addiction to crime. The man or the woman, the husband or the wife, is addicted to crime or is addicted to drugs or sexual obsession. The man or the woman can't stay without sex, with the result that once his partner is away for a couple of hours, that other partner is already having sex with someone else. This is unreasonable behavior. Fighting with neighbors, fighting with your husband, or the husband beating his wife every time is also a kind of unreasonable behavior. Yes, but it also includes temperamental outbursts, hot temper, which could lead to someone destroying something in the house, including life. All of these are examples of unreasonable behavior. And if the partner who is the injured party or who is the victim in this situation applies to a law court, providing this as evidence, the court will dissolve the marriage for the safety of the other partner. Now we talk about desertion. Desertion means abandonment. One partner has abandoned the other, left to stay elsewhere. It is enough for a law court to grant divorce to the partner who has applied for it using desertion as the evidence. However, desertion can also be constructive. It's what is called constructive desertion. If the partner at home, the one at home, is the reason why the other person has left, then the one at home is actually the one guilty of desertion. I give you examples. Through the behavior of a partner, for instance, a man smokes heavily, and the fume and odor of hard drug and tobacco fills the house every time, and the children keep inhaling it. And the woman is uncomfortable in such an environment. Or the woman is abusive of her husband. She is insolent, she insults her husband in the house, insults him in public, and easily picks a fight against him. or she or he engages in other kinds of conduct which, unable to tolerate, the other partner decides to move away and stay elsewhere. That partner at home is the one guilty of desertion. So the other partner who has moved away can apply to a law court using desertion as evidence, and the law court will dissolve the marriage. Apart from desertion, we talk about separation. If a partner has abandoned his wife or husband to stay elsewhere for 2 years, and the other partner, the one abandoned, gives his consent or her consent, then the court can dissolve the marriage on the basis that they are no longer married because one partner has left the other. However, if the separation has lasted for up to 3 years or more, then the consent or agreement of the other partner is no longer needed. The court will grant divorce to the partner who applies for divorce, providing as evidence that they have not been living together for up to 3 years or more. The consent of the other partner is not needed in this case. Then the ninth ground or factor is refusal to restore conjugal rights. A conjugal right is the right of a married partner to have sex with his or her spouse anytime, anywhere he needs it, provided that there is some privacy for them. If the other partner has consistently denied his or her partner sex, and the partner who is the victim applies to a law court asking for or requesting for divorce because he or she has been denied sex, and the court orders the other partner to restore conjugal rights, and after this court ruling, the offending partner still refuses to have sex with her partner or with his partner, then if that partner who is the victim applies to the court for a second time, the court will dissolve the marriage. Then, number 10, presumption of death. If a partner suddenly disappears and no one knows where he or she is, and there is no way of communicating with him or her, and years have come and gone, the surviving partner can apply to a law court requesting for divorce on the basis that it is now assumed that her husband or his wife is dead. The reason why this kind of application is necessary is that the law provides that if partners who were joined in a statutory marriage do not dissolve the marriage and one of them gets married a second time, it will amount to 5 years imprisonment if it comes to the knowledge of the court. So, if a partner presumes that the long disappearance of her husband or his wife has resulted in death, the man or woman is as good as dead because nobody knows his or her whereabouts. The surviving partner can apply to a law court and get a divorce. This is possible. However, by way of rounding off, there are some salient points that I need to raise here. One is called connivance. The partners have connived to deceive a law court, to tell the court that one of them is missing, and that because of that, divorce should be granted to them. This is not possible. If the law court discovers this, then the marriage will not be dissolved. The partners have to present a better reason, a more cogent, there's more cogent evidence for the divorce they are seeking. Then the other one is what is referred to as condonation. Condonation. If a woman has committed adultery and eventually her husband resumes sexual relation with her, it is assumed that he has forgiven her. If she now applies to a law court requesting for divorce on the basis that his wife is guilty of adultery, and it is known that he has been relating sexually with that wife, that information nullifies his application. The court will no longer grant it. Because you can't say you dislike something while at the same time eating it. If adultery is repugnant to a husband, then he should have nothing to do with the wife who has committed adultery. But if, in spite of the repugnance, he still goes to bed with her in the night or any other time, he has forgiven her and their marriage will continue. However, it cannot be the other way around. If the man is the one guilty of the adultery and his wife applies to a law court requesting for divorce, and the court discovers that the man has been having sex with his wife even after the adultery, the court will still go on to dissolve the marriage, because a woman finds it more difficult denying her husband sex. A husband can force his wife to have sex with him in a way that a woman cannot force her husband to have sex with her. So if a woman continues having sex with her husband, even after the man is found guilty of adultery, it is not assumed that she has forgiven him. It is assumed very simply that she is helpless in her situation. So she can't stop the husband from having sex with her. Now, another point is this. A woman has arranged for her husband to have sex with another woman, and children have been produced through that woman. Then eventually, that same woman applies to a law court requesting for a divorce, providing as evidence the fact that her husband has been sleeping with another woman and having sex with her. The court will not grant the divorce once it is discovered that her husband's sexual relation with that other woman was engineered by his wife proper. So, my treasured viewers, this is our discussion today on divorce or dissolution of a statutory marriage. If you have enjoyed this session the way I have done, like this video and share it so that other people out there can avail themselves of it, and subscribe to this channel so that you receive our videos firsthand in your inbox. And that way, you will also be encouraging us to give you more videos of this nature. And if somehow through this channel we succeed in saving some marriages, then I'd like to tell you that I can beat my chest the way I am sure you would do, and we'll tell ourselves that our partnership has helped the society to move forward on the path of progress. I remain your humble anchor, the human rights wizard, Ogochukwu Onwa. Remember our slogan on this channel: know your rights, protect your rights, defend your rights, and by so doing, we will create a just and harmonious society. I invite you to join me on our next video. Thank you very much for being a part of progress, and stay out of harm's way. Goodbye.